first test always about whether or not someone is under the FLSA is to determine if they're an employee or a contractor. Um, and it has to follow, it has to fit the interstate commerce test. So in order to be eligible, it has to be engaged in interstate commerce. There's two different types of coverage under the Fair Labor Standards Act. There's individual coverage. If the individual's employee's job involves interstate commerce directly, then the individual is covered. And the enterprise coverage, if the employees of a business will be covered if the business is engaged in interstate commerce or in producing goods for interstate commerce and meets a minimum gross annual revenue requirement of $500,000. So in order to be covered by the FLSA, it has to fit either individual or enterprise coverage, and that and specifically talking about $500,000 in gross annual revenues, which is not that difficult to reach. It's actually fairly low threshold considering everything. So who's covered? The FLSA applies to part-time and full-time employees. Federal, state, and local public employees are covered. It doesn't cover domestic workers, but there are some exemptions. Um, for example, in agriculture, right? Internship pay fluctuates. Former versus Trump era DOL rules cite different specific criteria. So in 2021, under Biden, we're going to have to check and follow up with that law to make sure that we're clear what the Biden administration believes would be considered internship pay or not. And so there, there's some examples there of what the Trump era was about, but of course, this book was put to rest before the election, so important for us to identify that even though this was published before the election, that there are clear changes that will already be happening since the administration shifted to Biden. Earlier DOL rules are more strict. That benefit had to flow almost entirely to the intern. So the rule basically means that the intern has to benefit from this and the employer cannot benefit from it. The goal of an internship is for the employee or the intern to benefit from this solely, that there's no benefit for the employer at all. They're only doing it for the goodness of their heart kind of thing. In terms of minimum wages, under the Fair Labor Standards Act, the federal minimum wage is $7.25 an hour, and that is enacted in 2009, but the buying power of that $7.25 has decreased by 17% since 2009. So you can buy 17% less than what you used to buy with the same amount of money. So our minimum wage is not keeping pace with the cost of living. This is a big, big problem. Originally, by the way, our minimum wage was 25 cents. It's the peak buying power for minimum wage was about 1968. So any boomer that tells you, oh, you could be able to do a good job with, having a minimum wage job. Yeah, well, that's because it's not 1968, so that's not happening. And I actually just had a conversation with someone very recently about people who were too lazy and didn't want to work. And, I had to explain to them that, the cost of living adjustment hasn't kept pace with the minimum wage hasn't kept pace with the cost of living. So it's pretty sad. There are bright lights, right? State and some localities have raised minimum wage rates. You can go to you can Google minimum wage by state, and you'll see an interactive map that will tell you what is the minimum wage, not only for your state, but if there are localities that are more than that, it'll let you know that too. So that's important. People who are learning or in training can get paid 10% less for their first 160 hours on the job with the expectation that they are in learning mode and are not fully capable of doing a job. So it is important that if you have to meet the criteria for what is considered to be a learner, but check in with the Department of Labor about what that actually entails to make sure that you're meeting the standards and not underpaying people, because again, wages and hours comes after you. It's costly. Piece rate is legal if it is at least equivalent to the minimum wage. So the minimum expectation of a piece rate, what people have to do at a minimum, has to meet the minimum wage. So has to meet $7.25 an hour at a minimum, or whatever it is at your state and local level. Tipped employees minimum wage is $2.13 per hour as long as the total pay exceeds hourly minimum wage. What that means is if the average tips that people get plus the $2.13 an hour meets um, the minimum wage for a particular area, $7.25 an hour at a minimum, but certainly more depending on where you're at, then you can keep your minimum wage lower. So if you make a tremendous amount of tips and only make $2.13 an hour, then you may not be eligible for a higher minimum wage, but because you're probably exceeding that minimum wage. So it's okay to keep the $2.13 an hour low as long as the average tips added into your hourly wage exceeds the minimum wage, meets or exceeds it. Certain occupations are overtime exempt per specific tests. Your textbook does a really nice job summarizing that. I'm not going to get into too much detail on it, but executive positions, administrative positions, professional positions, outside sales, and some degree of IT/computing jobs. In terms of overtime provisions, covered employees working over 40 hours per week are entitled to overtime pay of 1.5 times the covered employee's regular hourly wage rate for hours over 40. Now, um, how you calculate your hours per week really depends on whether or not the company pays for your lunchtime or not. So if they pay for your lunchtime, then 40 hours is 40 hours. If they don't pay for your lunchtime, then really you're only working 35 hours a week, assuming they give you an hour lunch break every day. And then, in which case, then you have to work 5 additional hours per week, and then your overtime starts kicking in. So you have to set the standard for the hours constituting a normal work week. You set the wage rates for the hours worked above the normal rate. And originally it was enacted to encourage more employers hiring to avoid an overtime penalty. Um, we wanted employers to hire more people. We didn't want them paying overtime. And in fact, occasional overtime is fine. People generally enjoy having an opportunity to make some overtime on occasion, particularly when it comes close to summer vacation time, when people want to have extra money for vacations, or having increased money around the holidays, Christmas time, for those that celebrate Christmas and who want to buy gifts for people, et cetera, et cetera. Um, but constant overtime is painful for employees and they start to wear down after a while. And then ultimately, they don't care. They don't even want to work the overtime. So it is important, first of all, if you have an overtime opportunity, absolutely offer overtime to your employees. That's all well and good. After that, then it's important for us to ensure that we are not overly burdening our employees with a constant barrage of overtime. And that was the whole point of the overtime provisions, is not to have that constant barrage, to not force our employees to have to work overtime all the time. As much as that money is good, it does wear you down, to particularly a labor intensive job. To work overtime 60 plus hours a week even can be a drain on people. So where is overtime exempt? FLSA minimum wage and overtime exemptions for 2020. The exemptions for white collar employees include executive, administrative, creative, or professional jobs as defined. The salary pay of at least $684 a week or $34,000 a year. $34,000 is not a lot of money, particularly if you're calling them white collar. Based on the cost of living today, $34,000 is not really executive level pay, right? I think our Congress is a little out of sync with the cost of living for things. Also, in order to get an exempt for an executive, your primary management duties is what you primarily do. You manage employees, you manage processes, you manage systems. You have oversight over a large number of people, and you have the opportunity to hire and fire people. An administrator has discretion, has independent judgment in significant office work. So that's what we would classify as someone who's an administrator. And again, that administrator has to make more than $34,000 a year in order to be exempt from overtime. Creative means people working towards invention, imagination, or talent in an artistic field. So if you have an artist, right, they're not going to get paid overtime for creating a piece of art. Professional is someone who's an intellectual that works in particular fields requiring advanced knowledge in science or learning or a prolonged course of specialized training. Doctors, lawyers, college professors, we don't get overtime. Highly compensated employees, similar to or above, plus annual compensation of over $107,000 a year, you're not obviously going to be eligible for overtime. The Fair Labor Standards Act prohibits employers from retaliating against any employee who exercises their rights under the Act, specifically regarding asking for overtime or minimum wage expectations. It also sets the minimum age standards for allowing children to work. Most cannot work before the age of 16. Sometimes they can for family run businesses and things like that, as long as it does not interfere with their health, education, and well being. And usually it's in family run farms, family run homes, family businesses where they can do some minimal work. Um, but most of the time we don't really want kids working before the age of 16. A, they don't have the maturity. B, it's a safety issue and we want them to be educated. We don't want them working. Age 18 is the minimum age for hazardous jobs and for many jobs to be able to drive others around. So we don't want people under the age of 18 driving people around in a school bus, say, for something, or an example like that. More protective state laws often supersede the Fair Labor Standards Act, so you should know what the labor standards are for children in your state if you're in a position where you might be hiring people who are under the age of 18. Family and Medical Leave Act was one of the last major pieces of legislation that was passed. This was done by Bill Clinton. The last legislation before that, dealing with employment laws and stuff like that, was um, the Americans with Disabilities Act. But this is the last sort of major comprehensive legislation, other than Affordable Care Act and things like that. The statutory basis for the Family Medical Leave Act says that employees are entitled to leave um, for a total of 12 work weeks of leave during any 12-month period for one or more of the following reasons: because of the birth of a son or daughter of the employee in order to care for such son or daughter, because the placement of a son or daughter with the employee for adoption or foster care, and in order to care for the spouse or son or daughter or parent or employee of the employee, if such spouse, son, daughter, or parent has a serious health condition, and because of a serious health condition that makes the employee unable to perform the functions of the positions of that employee. So under the Family and Medical Leave Act, if you need to take doctor's visits that are required because of a health condition, you're entitled under the Family and Medical Leave Act to be able to do that. For the birth of a child, or the adoption or foster placement of a child, to care for an immediate family member, and that includes spouse, son, daughter, or parent of that employee, but it doesn't account for anything outside of that. If you're not married, you don't get the time off necessarily, or you're not the company's not obligated to give you time off to care for your partner's parents. So this is where the inequities for a long time for LGBT employees who had same-sex partnerships and weren't legally allowed to get married, if their partner had children and something happened, they couldn't take time off under that. And so you can see how these very complex interplay of laws and social issues were having an impact on people's ability to do their job well. And there were a lot of avenues that were particularly unfair for people. So the Family and Medical Leave Act was enacted in response to female employees' concerns about job retention after having a child, because you could not be fired under the Pregnancy Disability Act um, for having a child, but there was no guarantee that you were going to have your job when you returned from maternity leave. They could give you a job anywhere doing, positions that were less, you were not qualified for, or perhaps doing a job that was less than what you had before. And so what this did was it guaranteed leave for birth, adoption, care of a sick child or spouse or parent, any dependent. It applies to employers with 50 or more employees within a 75-mile radius. So let's say you have a branch here and you have a branch in, say, Clayton, and you have, 25 employees here and 25 employees there. They're within a 75-mile radius of each other. So therefore, it's a total of 50 employees in that 75-mile radius. So basically, you take where you're at, 75-mile radius all the way around, and you should be able to count how many employees you have within that area, right? Basic math. Everybody says we don't use math. We do. Um, but 75-mile radius of where your job is located. And you should have 50 or more employees in that radius. Employers can require medical confirmation of the illness, and the leave is unpaid under the law. Now, that doesn't mean that the company can't pay people, but they're not obligated to pay them. And of course, very few companies are actually going to pay people if they don't have